The last time I saw my son-in-law, Kenneth Ashford, looking confident was on a Wednesday morning in March. Standing in my kitchen doorway, watching me sign a document I hadn't read, I remember the pen felt heavier than it should have. I remember thinking that was strange. I also remember his smile. My name is Dorothy Ashford. I'm 63 years old, and for most of the past decade, people in my family, including my own daughter, believed I didn't understand property law, estate planning, or what happens when a deed gets transferred without proper consent. That wasn't an accident. It was something Kenneth built carefully, one condescending comment at a time, over 12 years of Sunday dinners and holiday gatherings and quiet moments when he made sure everyone in the room was paying attention to him instead of me. But that Wednesday morning was different, because by the time Kenneth was smiling at me across my kitchen counter, I already knew what was in that document. I had known for 6 weeks, and I had been waiting for exactly this moment. What I hadn't anticipated was how completely his world would unravel before summer arrived. I need to start a little earlier. Not at the beginning, that would take too long, but far enough back to explain how a woman who spent 30 years as a paralegal ended up signing papers she pretended not to understand. My late husband Gordon passed away 4 years ago this November. We had 31 years together, most of them good, the last 2 difficult in the way that illness always makes things difficult. When he died, he left behind a modest estate, our home in Denton, a small rental property on Wicker Street that my parents originally owned, and enough in savings to keep me comfortable without working. Gordon was thoughtful that way. He also left specific instructions in his will about the Wicker Street property. He wanted it to remain in my name, not jointly held, not transferred, mine, until I chose otherwise. My daughter Suzanne had married Kenneth Ashford 8 years before Gordon died. She was 32 when they met him at some networking event downtown, and she came home talking about how impressive he was. Smart, ambitious, had his own real estate development company, knew everybody worth knowing. I remember listening to her and thinking that the most impressive people I'd ever met rarely talked about how impressive they were. But Suzanne was happy, and Kenneth was polite enough in those early years. Attentive, even. He remembered birthdays. He showed up on time. He gave the kind of compliments that sound generous, but carry a small edge you don't notice at first. "Dorothy, you're so wonderfully practical," he said once, at Christmas dinner, after I suggested a simpler solution to a problem he was overcomplicating. Everyone laughed. I laughed too. I was practical. I was also, apparently, not sophisticated enough to understand the kind of complex financial thinking that men like Kenneth engaged in. That became a running theme. Not cruel, never openly disrespectful, just consistent, just enough to establish a story. "Mom doesn't really follow real estate," Suzanne told a friend once, not meanly, just as fact, as something she'd absorbed without examining. "Property law gets complicated," Kenneth said whenever I asked questions. "I wouldn't worry about the details." The details, as though 30 years spent reading contracts and filing deeds and drafting legal correspondence had left me somehow unequipped to follow a conversation about property ownership. I let it go. That's the part I return to sometimes, lying awake at the lake house now, listening to the water. I let it go because Gordon was sick, and then because I was grieving, and then because the path of least resistance felt like the only path I had energy for. I told myself it didn't matter. I told myself Kenneth's opinion of my intelligence was his problem. What I didn't fully account for was what he might do with that opinion. The first sign came about 18 months after Gordon died. Kenneth mentioned, casually, over dinner, that the Wicker Street rental was probably generating less income than it could. The neighborhood was changing. Values were rising. He had a developer contact who might be interested in a conversation. I said I wasn't ready to make any decisions about the property. He nodded. He changed the subject. He poured more wine, but 3 weeks later he mentioned it again. Different angle, same destination. And then again a month after that, each time wrapped in concern. "Just want to make sure you're maximizing what Gordon left you." Each time carrying the suggestion that a woman my age shouldn't be navigating this alone. I started paying closer attention. Not dramatically, not suspiciously. I simply began keeping a folder. Notes from conversations, dates, exact words when I could remember them, nothing that would alarm anyone. Just the habit of a woman who spent 3 decades in a law office and never fully stopped thinking like one. What I noticed over those months was a pattern. Kenneth never pushed too hard in any single conversation. But the conversations were more frequent than they appeared, and they always moved in the same direction. Toward one conclusion, that the Wicker Street property would be better off in different hands. Then something changed. About 8 months ago, I began receiving mail addressed to a company I didn't recognize. Ashford Property Holdings, LLC. The return address was a post office box in our county. One envelope looked like a legal notice. Another was a bank statement. Both were addressed to me, care of that company name. I was not a member of any LLC. I had never agreed to form one. I had never signed articles of organization, operating agreements, or anything that would put my name on a business entity I didn't create. I placed them carefully in my folder. Then I drove to the county recorder's office on a Tuesday morning when I knew Kenneth would be at a site meeting in Frisco. What I found there made me sit down in a plastic chair and stare at the ceiling for a long time. Ashford Property Holdings LLC had been registered 6 months earlier. The registered agent was a name I didn't recognize, a man named Todd Greer, but listed among the company's members with a 30% ownership stake, Dorothy R. Ashford. I had never heard of Todd Greer. I had never agreed to any partnership. I had never received any disclosure, any notice, any communication that would suggest someone was using my name to form a business entity connected to the Wicker Street property. My hands were very still on the drive home. That's what I remember. Not shaking, just still, the way hands get when the body is working too hard to process something, to spare energy for trembling. That night, I called my oldest friend, a woman I'd worked alongside for years at the firm before she retired, Gwendolyn Marsh. Gwen had moved to Tucson, but we still talked every few weeks. She answered on the second ring the way she always did. When she heard my voice, she paused. "What happened?" I told her everything. She didn't interrupt once. When I finished, there was a long silence. "Dorothy," she said finally, "you need someone who practices real estate law, not a paralegal, an attorney." "I know. And you need to be very careful about who else you tell." I understood what she meant. Because there was another name I hadn't mentioned yet. Another person connected to this situation, someone whose involvement, if confirmed, would change everything. My daughter, Suzanne. I didn't want to believe she knew. I want to be honest about that. A part of me spent weeks constructing reasons why she couldn't possibly be involved. She was busy with her own work. She trusted Kenneth completely. She took his word for things the way she always had. There were innocent explanations. I looked for them. But I also remembered small moments that I had filed away and tried to forget. Suzanne changing the subject when I mentioned Wicker Street. Suzanne suggesting, twice, that I should let Kenneth handle the paperwork when property tax statements arrived. Suzanne's voice going flat and careful when I said I wasn't ready to sell. I didn't confront her. Not yet. I needed to understand the full picture before I reacted to any piece of it. Instead, I called an attorney. Her name was Patricia Holloway, and she'd been practicing property and estate law in our county for 20 years. We met on a Thursday afternoon in her office downtown, and I brought everything. The LLC registration, the mailing addresses, the notes from my folder, Gordon's will, the original deed to Wicker Street, 18 months of dinner conversations I'd quietly reconstructed from memory. Patricia reviewed everything without expression. That's a skill attorneys develop. Keeping the face neutral while the mind is working. When she finished, she looked up. "Mrs. Ashford, do you know whether your signature appears on any of the LLC formation documents?" I told her I hadn't been able to access the full filing. She pulled the documents herself using the county record systems. We found my signature on 3 pages of the operating agreement. I had never signed those pages. Patricia's face remained composed. Her voice did not change. But she asked me one question that told me everything about how seriously she was taking this. "Has your son-in-law ever had access to documents that carry your actual signature?" The answer was yes. 2 years earlier, I had signed a routine property insurance renewal that Kenneth handled as a favor. I'd signed it at the kitchen table while he waited. He'd taken it with him when he left. Patricia made a note. Then she said something I have thought about many times since. "Mrs. Ashford, I want you to continue behaving exactly as you have been. Don't change anything. Don't confront anyone. Let me do some research, and let's talk again next week. I agreed. I drove home. Kenneth's car was in the driveway. He was inside, helping Suzanne move some furniture, apparently, something domestic and ordinary. He greeted me warmly. He made coffee. He told a story about a project he was developing out near Prosper, and he used all the words people use when they want to sound authoritative. Acquisition, leverage, upside potential, long-term positioning. I sat at the kitchen table and drank my coffee and smiled in the right places. The following week, Patricia called me with research that made the picture considerably clearer and considerably worse. Ashford Property Holdings LLC had, over the previous 4 months, entered into a preliminary development agreement with a commercial construction firm. The agreement referenced the Wicker Street property as a primary asset of the LLC. There were loan instruments attached, not yet executed, but prepared, that would have used the property as collateral. The potential liability attached to my name was substantial, well into 6 figures. None of this had been disclosed to me. None of it had been authorized by me. This is beyond a paperwork error, Patricia told me. And I think you already know that. I did. She also told me that the development agreement included a co-signature line. On the preliminary documents she'd accessed through public filings, a second name appeared alongside Kenneth's. Suzanne Ashford. The room went very quiet when she said it. I was sitting in the sunroom of my house, the same house where Suzanne had grown up, where her father and I had raised her, where she had come home for holidays and summers and all the years in between. I stared out at the backyard for a long time after we ended the call. There's a grief that comes with betrayal that has nothing to do with anger. It comes later, after the shock. It settles in like weather, and it's heavier than anger somehow. Anger has momentum. This other thing just sits there. I gave myself 2 days to feel it. Then I went back to work. Patricia and I developed a plan. Careful, methodical, built on documentation rather than emotion. Because that's what 30 years in a law office teaches you. Emotion is real, but evidence is what matters in a room where decisions get made. Over the next 6 weeks, I continued to behave as though nothing had changed. I had Sunday dinners with Suzanne and Kenneth. I asked about their lives. I listened to Kenneth talk about his projects. I watched how they looked at each other when my name came up in conversation about the property. That quick glance, the slight adjustment in posture. I filed each observation away. One Sunday, Kenneth mentioned that he had some insurance paperwork that needed my signature. Something routine, he said, related to the property. He'd bring it by Wednesday. I told him Wednesday worked fine. I called Patricia that evening. She told me exactly what to expect. Wednesday morning, Kenneth arrived at 9 with a folder. He set it on the kitchen counter and flipped to a page with a signature line, explaining it the way he always explained things to me. Slightly too simply, as though he was translating from a language I wasn't quite fluent in. Standard renewal, he said, just updating the coverage information. I looked at the document for what felt like a long time. It was not an insurance renewal. It was a transfer authorization that would have moved the Wicker Street property into Ashford Property Holdings LLC as a contributing asset. I picked up the pen. I signed. Not the document. A blank sheet of paper I slipped beneath it at the last moment, something I'd practiced twice the night before. A habit I'd read about years ago in a fraud case we'd worked at the firm. Kenneth collected the folder without examining what I'd signed. He smiled. He said he'd take care of the rest. He left. I stood at the kitchen window and watched his car back out of the driveway. Then I called Patricia. What followed over the next several weeks was not dramatic in the way that stories sometimes are. It was procedural. Filings, correspondence, notifications to the county recorder's office, formal inquiries to the state attorney's office regarding the fraudulent LLC registration. Patricia moved methodically, the way good attorneys do, building the record one piece at a time. Kenneth discovered something was happening. About 3 weeks after his Wednesday visit, when he attempted to proceed with a loan instrument, using the Wicker Street property as collateral, the lender, having been contacted through proper legal channels, informed him that the property's ownership status was under review and no transaction could proceed. I was not present for that phone call. But Suzanne called me that evening, and I could hear in her voice that something had broken loose. "Mom!" Her voice was tight. Careful, I think we need to talk. I said yes, I'd been waiting. She came alone. Kenneth wasn't with her, and I suspect that was deliberate, though I never confirmed it. She sat across from me at the kitchen table, the same table where I'd signed the blank sheet of paper 3 weeks earlier, and for a long time neither of us spoke. When she finally did, she didn't offer excuses immediately. That surprised me. What she offered first was a question. How long have you known? I thought about the right answer. Long enough to be careful about it. Her eyes filled. She looked down at the table. I didn't know about the signatures, she said. I need you to know that. I didn't know how he was doing it. I waited. Because there's always a but. But I knew about the LLC. I knew what the plan was. The words came out quiet and honest, and they hurt the way honest words do when you've already suspected them. Why? It was the only question that mattered. Suzanne was silent for a long time. Then, she said something I've turned over many times since. He kept saying you didn't need it, that you had enough, that the property was just sitting there and we could build something real with it. A pause. And I wanted to believe him because I wanted what he was building to work. The tragedy of that answer is how recognizable it was. Wanting to believe someone you love, letting that want override what you already sense. I had done it myself, at different points in my life. Most people have. But he forged my signature, I said. Suzanne closed her eyes. I know. She said it like someone who had already been carrying that knowledge and hated the weight of it. And I believed her, that she'd known, and that she'd told herself it would be fine, and that she had lived with the discomfort of that justification longer than she wanted to admit. I reached across the table. Not because everything was resolved. Not because the damage had disappeared, but because she was still my daughter, and the look on her face was the look of someone who had finally stopped lying to herself, and that moment deserved acknowledgement even if it couldn't fix what came before. You're going to have to be truthful, I told her. With Patricia. With whoever asks. She nodded. I know. Kenneth did not respond the same way. When he understood the full scope of what Patricia had documented, the fraudulent LLC registration, the forged signatures, the attempted collateral fraud, the preliminary development agreements that misrepresented the ownership structure of the Wicker Street property. His first response was anger. His second response was denial. His third, which arrived about a week later through his own attorney, was an offer. He wanted to discuss a settlement. A financial arrangement that would compensate me for any confusion around the paperwork and allow the LLC to proceed with revised terms. Patricia read me the letter over the phone. When she finished, there was a brief silence. What would you like me to tell them? She asked. I thought about the Wednesday morning when he set that folder on my counter and smiled at me like a man who had already won. I thought about 12 years of being the woman who didn't follow real estate. I thought about Gordon's careful instructions in his will and why he had written them, and whether on some level he had suspected that the people around me might one day need to be reminded that the Wicker Street property was mine. Tell them no, I said. The formal proceedings moved forward. The state attorney's office opened an inquiry. The LLC was dissolved. The Wicker Street property remained in my name, undisturbed, exactly as Gordon had intended. Kenneth's development agreement collapsed when the primary asset he'd been representing as part of the deal turned out to have been misrepresented in the filing documents. There were legal consequences. I won't detail all of them, because some of it is still ongoing, and because the outcome matters less than what it revealed. What it revealed was that a man who had spent over a decade constructing a story about my limitations had built his entire scheme on the assumption that I would never look closely at my own affairs. That assumption was his only real mistake. The hardest part of everything that followed wasn't the legal process. It was Suzanne. She had chosen honesty when it mattered, and that choice cost her. She and Kenneth separated in the early spring. She moved into an apartment on the east side of town, about 20 minutes from my house, and for the first several weeks she came by almost every day. Sometimes to talk, sometimes just to sit. One afternoon we were on my back porch, drinking iced tea, and she said something that I think about often. She said, I watched him do it to you for years, and I thought that was how he talked to everyone. Like everyone else was slightly less informed than he was. Some people are like that, I said. I know, but I should have seen what it meant. I let that sit. Then I said, You saw it eventually. She looked at me. Because of you. Because of you choosing to see it, I said. That's different. We sat quietly for a while. The yard needed tending. It always needed tending in April, and neither of us moved to do anything about it. Some afternoons the only thing you can do is sit with what happened and let it settle into something you can live with. The Wicker Street property stayed in my name. I did eventually have a conversation with a legitimate property manager about maximizing the rental income, and I made those decisions myself with full information on my own schedule. The property isn't dramatic. It isn't a windfall. It's a 2-bedroom house on a quiet street that my parents bought in 1974, and it belongs to me because Gordon made sure of that, and because I paid attention when I needed to. That's what it comes down to in the end. Paying attention. I think about the women I know, the ones my age, the ones a little older, the ones who came behind me, and how many of them have been told in 100 small ways that financial matters are complicated, that they shouldn't worry, that someone else is handling it. I think about how reasonable those messages sound, how much easier it is to accept them than to push back. I was a paralegal for 30 years. I read documents for a living, and even I let it happen, slowly, incrementally, because the person telling me I didn't need to understand was someone I trusted, and because the moments of doubt were always small enough to explain away. So I want to say something plainly to anyone listening who recognizes any piece of this story. You are allowed to read what you sign. You are allowed to ask what something means. You are allowed to make phone calls and visit offices and request copies of your own records. You are allowed to say, I want to think about this and mean it, and not be embarrassed by it, and not apologize for it. Your name on a document is your name. No one gets to attach it to something without your knowledge. Not a husband, not a son-in-law, not a business partner, not anyone. And the moment someone seems annoyed by your questions, that annoyance is information. Gordon used to say the most valuable thing a person can own is their own good judgment. He said it mostly about other things. But I've thought about it a lot this past year, sitting on my porch watching the light change over the backyard, feeling, for the first time in a long time, like I'm living in a house that's entirely mine. Not just the deed, the whole thing. The paperwork, the decisions, the morning coffee, the afternoon quiet, the knowledge that nothing is happening in my name that I didn't choose. A year ago, I was a woman people thought didn't follow real estate. Now I teach a monthly workshop at the county library for women navigating property and estate questions on their own. Nothing formal. Just a table, some handouts, and a lot of honest conversation about the kinds of things women are often told they don't need to understand. Last month, a woman in her late 70s sat across from me after everyone else had left. She had a document in her hand, something her nephew had asked her to sign. She wasn't sure what it was. We read it together. She didn't sign it. That, more than anything else that happened this past year, is what I think Gordon would have recognized as the whole point.